Hello, good afternoon. Well, we are here again in this second video. I hope that it will be shorter than the first one. For sure, it's going to be shorter than the first one. First, some practical informations. As you know, we had a practical exercise on March 24th. And as I have explained to you, we are not going to have this exercise due to the circumstances. So we should introduce a new exercise. And well, after thinking a time about the different possibilities at the end, I think that the best is to have this exercise the 31st of March. 31st of March. So we are going to do this exercise online. I'm almost sure that that day we are going to continue without the possibility of having face-to-face classes. So we are going to do that exercise online. I'm going to show you now the way we are going to follow to do this exercise. In the Moodle, there is a possibility called assignments that allows to put a task, and then you have certain time to do that task and to send me that task through Moodle. This is important, through Moodle. I'm sharing with you the picture showing the Moodle space in order to see how does look like, and you are going to use Moodle to send that exercise. That is a very important part. Some of you have asked me how to send me the previous exercise, and you can send me that kind of exercise, the exercise we have already made, and the next exercise we are going to do that are not relevant directly for the final mark through email. So we are going to use email to send the exercises. You can use my email, rafael.arenas.uab.cat, in order to send your exercise. But as this exercise I'm talking about, the exercise of the 31st of March, that is an exercise with relevance for the final mark. This exercise should be made through Moodle, through this tool in Moodle called assignments. So at 12 o'clock, I'm going to share through Moodle the exercise, and you will have 3:15 to answer the exercise. At 12 o'clock, March 31st, I'm going to share the case, the exercise through Moodle, through this tool called assignments. And then you will have the possibility to answer through Moodle this exercise you are going to have the possibility to answer this exercise through Moodle till 3:15. The exercise is relatively short. In normal circumstances, 1 hour and a half will be enough to answer the exercise, or even shorter than that. But as we are in these circumstances, you are going to have 3 hours to answer the exercise. Of course, you can use whatever you want to answer the exercise, and I will evaluate this exercise, and I'm going to give you back the marks the shorter as possible. I hope that everything is clear. So, as I have already explained, we are not going to have the exercise scheduled the 24th of March. This exercise will we are 31st of March at 12 hours, and you are going to have 3 hours to answer this exercise through Moodle. So the last day of March, I hope that all of you will be with your computer answering this exercise as in a normal exam, but online. This is the only difference. If you have any doubts, as I have said to you, you can ask your doubts through mail or demand a meeting through Skype. I hope that everything is clear. So this is the first point. The second point, I'm going to give you some feedback about the first exercise. So the exercise, many of you have sent me your exercises. Some of you are still asking me in which way you can send me the exercise, of course through mail, and it's not important that the final day has already passed. You can continue send me your exercises, and I will take a look at the exercises. The exercises I have read till now, well, there are differences, of course. There are exercises more elaborated, more accurate, more in detail. There are other exercises more in general, but the answer is correct in almost all the exercises I have read. You have realized that we are facing a problem that there are two parts, jurisdiction, and in jurisdiction all of you have applied regulation 1215/2012, and in the applicable law you have considered Rome 2 regulation. That's correct, that is perfect, so great. Some points. Some of you have said not regulation 1215/2012, but Directive 1215/2012. Some of you have said directive instead of regulation. That is a mistake, because this is a regulation, not a directive. And the distinction between regulations and directive is very important in European Union law. Most of you have said correctly regulation, but some of you have written directive. This is not correct. So you must take care with that. If you have any problem in the distinction between regulations and directives, please ask me, because it's very important to have clear this distinction. So there is another point. The case, well, the case is not, it wasn't very easy, because it's a case involving contractual and non-contractual liability. Some of you have explained that in a very correct way, that there are aspects that should be considered from a contractual point of view, and aspects that should be considered from a torts point of view. That's important. We are not going to enter now in the contractual perspective, because we are going to see this contractual perspective in lesson 4. In lesson 4, we are going to enter into details in the regulation of international contracts. Now we are focusing in torts litigation, non-contractual liability. But in cases of unfair competition, and in cases of unfair competition linked to distribution, like this case, that is not, it's not a real case. This case is not a real case, but there are many real cases very similar to this case. And in this kind of cases, very often there is an allegation, a claim based in contractual liability, and an allegation based on torts. This is very common. The allegation mix between contractual and non-contractual aspects. So if we are paying attention to contractual aspects, contractual claims, in that case the contractual claim can only be introduced against Ton Laherm, against Thunder, because the contractual relationship is between Thunder and Ton Laherm, and in this case it's possible a contractual action and also a extracontractual, a tort actions. Even in the case that there is a contract, it's possible to have an extracontractual, non-contractual torts claim. We are not going to enter now in this, but it's possible. It's possible to have a claim based on unfair competition, even between Ton Laherm and Thunder. But if there is a contractual claim, then it's important. If there is a contractual claim, then the jurisdiction should be based in Article 4 of the Brussels 1 bis regulation and Article 7.1. Some of you have used in the contractual claim Article 7.2 of Brussels 1 bis regulation. This is not correct because 7.2 is the ground of jurisdiction for torts, not for contractual claims. So if we are focusing in the contractual claim, the relevant articles are Article 4 and Article 7.1. Is not relevant Article 7.2. If we are considering the unfair competition ground of jurisdiction, tort ground of jurisdiction against Thunder, then we are going to consider Article 4 and Article 7.2. And if we are considering the action, the claim of Ton Laherm against Lavent, then we are going to consider Articles 4 again and Article 7.2, because between Ton Laherm and Lavent there is no contract. There is no possibility of a contractual claim. I hope that this is clear. I repeat, it's a complex case and was asking only for the unfair competition action. And if we consider the unfair competition action, that can be used even against Thunder, although there is a contract between Ton Laherm and Thunder, that makes not impossible a claim based on unfair competition between these two parties. And if we are considering the action based in unfair competition regulations, in unfair competition law, then we are going to consider in jurisdiction Article 4 of the Brussels 1 bis regulation and Article 7.2. And in the action of Ton Laherm against Lavent, then we are going to consider Articles again 4 and 7.2. Another point, Article 4 is based on the defendant's domicile. Where is the domicile of Thunder? Well, it's important to know that according with Article 63 of the Brussels 1 bis regulation, Thunder should be considered domicile in the country where Thunder has its registered office, because it's the statutory domicile that in the case of United Kingdom and Ireland is the place of the registered office of the company, and in the place where is the central administration of the company or the principal place of business. You can consider, the plaintiff can consider the three places as the defendant's domicile. So Thunder is domiciled in the United Kingdom and in the Netherlands. And both of these countries can be used by the plaintiff in order to introduce the claim. Some of you in your answer didn't explain that correctly. There is a doubt about if you are considering only one of these connections. And it's important to realize that the actor, the plaintiff, can use any of these connections, can use the connection based on the statutory domicile, that is the register office in this case, the connection coming from the main administration, the central administration, and the connection coming from the main place of business of the company. So this is another point you must take into consideration. And another point, well, let me see what another thing you have explained. Yeah, the application in time of regulation Brussels 1 bis. Some of you have based the application of regulation Brussels 1 bis from the point of view of time, the application in time of the regulation, taking into consideration the date of the contracts, of the signature of the contracts. This is not correct. The key moment for taking into consideration the application of the regulation is the introduction of the claim, when the claim is introduced in the court, before the court. This is the relevant moment to determine whether we are going to apply the regulation Brussels 1 bis or not. It's not important the moment of the contract. There are some slight exceptions. I'm not going to talk about them now. But in general, we should consider the moment we are going to introduce the claim. When the claim is introduced, when the regulation is in force in the country of the court, then the Brussels 1 bis regulation will apply. I hope that this is already clear. If you have any doubt, please let me know. Well, so I'm going to continue with the point we have now, but before, now I'm going to end with this lesson 2. At the end, I'm going to share with you not only the video, but also the PowerPoint with the whole lesson. And next week, I'm going to share with you another video on lesson 3, companies in international commerce law. 2 videos, in fact. I will share with you one video on Tuesday and another video on Friday, the same than this week. At the end of the first video, I'm going to propose you not an exercise to send to me, but the reading of some materials. It's not necessary to do anything more than reading the materials, but it's better before the second lesson, the reading of that materials. Case law, basically case law of the European Court of Justice in Luxembourg. So next week we are going to have these 2 videos. At the end of this video, I'm going to propose you another exercise, and you are going to have the whole week to answer that. So send me your exercise in the moment you want within the next week. And I will read the exercise, and in the first video after that I will give you feedback about your answers. But I think that it's better to give you more days to do your work. I suppose that at this moment all the teachers are giving you materials to read and to work, and it's better to have more time to answer the questions and the exercises we are proposing to you. So the idea is that at the end of this video you will have an exercise about product liability, and you will have all the next week to answer that video, and you will obtain your feedback in the next video after the next week. And I will provide you with 2 more videos about company law in the next week. One video on Tuesday and another video on Friday. And between the 2 videos, you have to read some materials. And you should prepare the exercise of the next week, the exercise of March 31st of March. And this exercise will be about the topics we have seen since the beginning of the course. So we have had an introductory lesson. It's very difficult. I can say to you that it's very difficult to put a practical exercise based on the first lesson. So the exercise will be based on the second lesson. The exercise we are going to have the last day of March will be related with patents, trademarks, designs, unfair competition, or product liability. These are going to be the topics that could be introduced in that exercise the last day of March. Company law will be won't be considered in this exercise. We are going to ask about company law in the exercise we are going to have in April. I hope that this is also clear. You work for your next week to do the exercise at the end of this video, to prepare the materials I'm going to give you next Thursday, and the preparation of the final of the exercise the last day of March. That it's an exercise related with patents, trademarks, designs, or unfair competition or product liability. That is the topic we are going to see today. I hope that this is also clear. And so, if all these questions are clear, we can move to product liability. This is also an important issue, an important topic for international commerce: the liability caused by a product. The damage caused by a product, and the liability coming from this damage. When a product causes a damage, and this damage can be a personal injury, or can be also a damage based on an economic loss, or can be a damage to property. When we are dealing with such kind of damage caused by a product, then we are in the field of products liability, which is the special this product's liability. Well, it's relative new, and this field was born when we realized that it's very difficult for the customer, for the person suffering the damage, to prove the liability of a person in the chain of production or distribution of the product. I mean, for example, we have a car that doesn't work properly, a car with a problem at the brakes, and there is an accident caused by that car because the failure of the brakes of the car. From a traditional point of view, of course, the person suffering the damage cannot introduce a claim against the car. The claim should be introduced against the company producing the car or the company that introduced the car in the national market, of the retailer of the car. But in each of these cases, there should be a proof of the personal liability of the defendant. If you are introducing a claim against the producer of the car, the manufacturer of the car, you should prove the liability of that company, of that person. And it's very difficult for the person suffering the damage to prove who in the production or distribution of the car was the person responsible for the damage. So, to change that, it was born a kind of liability linked to the product. So, any person taking part in the distribution or production of the product then can be object of a demand coming from the I will say coming from the product, but as we are going to say, it's broader than the product. They could suffer a claim that person taking part in the production or distribution of the product can be object of a claim based on the product. Linked to the product, because some area is linked to the defects in the product. When we are dealing with a defective product, the product doesn't, with the use the product is intended to, the product is dangerous or harmful, the product is dangerous because of the design, the assembly, or any other aspect of the manufacture of the product. This is a defective product. And in these cases, we can have a damage, and the persons, I repeat, taking part in the production or distribution of the product could be liable for this damage caused by this product. This is one idea. And the other idea is that the persons taking part in the production or distribution of the product are also responsible for the misdescription of the product the failure to give adequate notice of the qualities of the product or its characteristics or its method of use. And this is important. It's not only the product, but also the instructions linked to the product. And we are going to see an example of that in some minutes. We are going to see an example of this kind of liability linked to the instructions of the product. So, till now, we are in a field, product liability, in which when a product, a damage is linked to a product, and we have seen that this link to a product could come because the product is a defective product, but also because the instructions of the product are not correct. For example, when we are dealing with a damage coming from a product in this broad sense, the person suffering the damage can introduce a claim against the persons, the companies taking part in the chains of production or in the chains of distribution of the product. That means manufacturers, distributors, suppliers, retailers, etc. I hope that this idea is clear. This is the specific feature of the product's liability. The liability in some way is linked to the product. Of course, at the end, the person who should respond is always a company or a physical person. But to understand how the liability is built in this area, we can think that the liability is built to the product. So at the end, you must prove that the product has a defect, is a defective product, or the instructions were not include some mistake, and there is a damage caused by this product, and then there is a liability of these people taking part in the chain of production or distribution of the brand. And this is important. We can think in damage caused by cars, for example. First, I was talking about the problems with brakes, for example, of any other part of the car, planes, or creams we can use for our skin, or pharmaceutical products, or any other product that, for any reason, cause a damage. I hope that this is clear. This is the field we are going to talk about. And as we have seen till now, we have to see two different problems: jurisdiction and applicable law. If we are talking about jurisdiction, we should consider regulation 1215-2012, the Brussels 1bis regulation. But I'm not going to say nothing more about this regulation, because it's what we have seen till now. Most of the cases, we are going to deal with a non-contractual liability. We are going to deal with claims based on torts. So we should consider Article 4 and 7.2 mainly, as we have seen till now. So I'm not going to say nothing more about that jurisdictions problems in product liability. And then we are going to move to applicable law. And in applicable law, we are in a different scenario, because in this area we have a very, very important convention. We are going to see the Hague Convention of 1973 on product liability. And we are going to see also the regulation we find in the ROM 2 regulation. In the ROM 2 regulation, there is an article devoted to product liability, Article 5 of the ROM 2 regulation. But we have also this High Convention of 1973. And why is this important, this convention? For example, in Spain is very important, and also in France, because both Spain and France are states parties in that convention of 1973. And although Spain and France are also member states of the European Union, courts in Spain and in France are not going to apply Article 5 of the Rome II regulation, but the High Convention of 1973. So, in case of product liability, the courts in Spain, in France, and the other member states of the High Convention are going to apply the High Convention, and they are not going to apply the Rome II regulation. So, from a practical point of view, this is important. This is an exception to the application of Rome II regulation. This is the reason we are going to consider the High Convention of 1973. In the rest of the countries, member states of the European Union, they are going to apply Rome II regulation. And this is the reason we are going to take a look also to the regulation we find in the Rome II regulation. The High Convention of 1973 is important for many reasons, of course. One of the reasons is that some of the features of the product liability regulation that I have explained before nowadays are clear because they were clarified in the negotiation of the Convention of 1973. In 1973, the product liability was a relatively new field of law, and this convention was important to settle the main features of this regulation. So the Convention of 1973, it's very important for this for the reason. And the Convention of 1973 has also two other important points that should be stressed. One of them, the convention doesn't, because it's in force, of course, doesn't enter into the distinction between contractual and non-contractual liability. And this is a very important and a very good point for the convention. As the characterization between contractual liability and non-contractual liability differs from one country to another, sometimes there are problems when we are dealing with international cases for the distinction, because of the distinction between contractual and non-contractual liability. So the convention, the path the convention found is that we are not going to distinguish. The convention will apply to contractual, non-contractual liability, product liability in the sense of the convention, and we are not going to enter between this difficult task of characterization. This is very important. And the other point is that the convention doesn't apply when the convention apply to all the for the liability of any person working or taking part in the production or distribution of the product, but the convention will not apply to the transporters. It's important, the carriers of the goods, and it's not going to apply to the liability of the person who has transferred to the person suffering damage the property in or the right to use the product. So the direct seller of the product to the person suffering damage is not into the convention. The convention is going to apply for the liability of the producer of the product, the distributor of the product, the seller of the product, but not to the person who has transferred to the person suffering the damage the product. The person at the bookshop, sorry, the bookshop. It's difficult to enter in a case of product liability caused by a book, but the person at the computer shop selling the computer is not going to be included in the liability, in the convention of product liability, in the case, for example, that the computer explodes and cause damage because there is a fire caused by the computer. In that case, this will be a case of product liability, and the convention will apply to the liability of the company making the computer and the person introducing the computer in Spain, for example. But the liability of the retailer, the shop selling the computer directly to the person suffering the damage, this liability is not going to be covered by the convention. I hope that this is also clear. So the idea is the convention applies to the liability to all the members of the chain of production or distribution, but not the person transferring the product to the person suffering the damage. That doesn't imply, of course, that this person selling the computer in the example we are using is not going to have a liability. Of course, that person could be liable, could be responsible, could be. I don't mean that this necessarily is responsible, but it could be responsible, but the liability of that person is not going to be covered by the Hague Convention of 1973. I think that this is another important point. So the Convention of 1973 covers the liability of every person involved in the production or distribution of the product, except this person selling the product directly to the person suffering damage. Is that clear also? I hope so. So, and which is the solution of the convention? Well, I must recognize that it's a very complicated solution. First of all, sorry, at this point, I have forgotten when I explained in the last video the Article 4 of the Rome II regulation. I have forgotten to explain to you one important point. So I'm going to say, please remember. Oh, it's impossible. You are not going to remember now that I must explain to you that. But I have to explain a point of Article 4 that I have forgotten to explain to you in the last video, and I'm going to do that after the explanation of Hague Convention of 1973. After the explanation of Hague Convention of 1973, when we enter into Rome II regulation in order to see Article 5 of the Rome II regulation, I will come back to Article 4 to explain one point I have forgotten to explain to you in the last video, the first video. So, coming back to Hague Convention of 1973. As it happened in Article 4 of the Rome II regulation, the order of the articles is not correct, because we have Articles 4, 5, 6, and 7, but the main article is Article 5, not Article 4. So, in first time, we should consider the application of Article 5. And in case that Article 5 cannot be applied, then we are going to consider Article 4. So, Article 5. Notwithstanding the provision of Article 4, so that means that Article 5 prevails over Article 4, the applicable law shall be the internal law of the state of the habitual residence of the person directly suffering damage, if that state is also the principal place of business of the person claimed to be liable or the place where the product was acquired by the person directly suffering damage. So, the connection is the residence of the person suffering the damage, but to apply that law, it must be another point of connection in that place, in that country. Either the principal place of business of the person claimed to be liable or the place where the product was acquired. When there is a coincidence between the principal place of business of the person claimed to be liable or the place where the product was acquired, then we are going to apply the habitual residence, the law of the habitual residence of the person suffering damage, when this place of habitual residence of the person suffering damage is the same that the place of the principal place of business of the person claimed to be liable or the country where the product was acquired. When there is this coincidence between the habitual residence of the person suffering damage and these two possibilities, either the principal place of business of the person claimed to be liable or the place where the product was acquired. When there is this coincidence, we are going to apply the law of the country where the person suffering damage has her or his habitual residence. This is the first possibility, Article 5. When Article 5 cannot be applied, because there is no coincidence between the habitual residence of the person suffering damage and these other 2 points, we are moving to Article 4. The applicable law shall be the internal law of the state of the place of injury when there is a coincidence. The coincidence between the state of the place of injury and the habitual residence of the person directly suffering damage or the principal place of business of the person claimed to be liable or the place where the product was acquired. These are the possibilities. When there is this coincidence between the place of injury and the habitual residence of the person suffering damage, the principal place of business of the person claimed to be liable, or the place where the product was acquired, we are going to apply the law of the state of the place of injury. This is the second possibility in the High Convention of 1973. This is the second possibility. When we cannot apply neither Article 5 nor Article 4, we are moving to Article 6. Where neither of the laws designated in Articles 4 and 5 applies, the applicable law shall be the internal law of the state of the principal place of business of the person claimed to be liable, unless the claimant bases his claim upon the internal law of the state of the place of injury. So, at the end, there is an option to the claimant. The claimant can base the claim in the law of the place of injury or the law of the principal place of business of the person claimed to be liable. At the end, when we cannot apply Article 4 and Article 5, the Article 6 establishes an option for the claimant, the person suffering damage. This person can choose between the law of the place, the principal place of business of the person claimed to be liable or the law of the state of the injury. Is that clear? There is a point we must consider. We haven't ended. We must to add a very, very important consideration. But the first is to have clear this line between Article 5, Article 4, Article 6, and the possibilities that are open in Article 6. that is clear, then we must consider Article 7, that Article 7 affects the three former articles. Article 7 must be taken into consideration when we apply Article 4, Article 5, and Article 6. Article 7. Neither the law of the state of the place of injury nor the law of the state of the habitual residence of the person directly suffering damage shall be applicable by virtue of Articles 4, 5, and 6 if the person claimed to be liable establishes that he could not reasonably have foreseen that the product of his own products of the same type will be available in that state through commercial channels. What does it mean? Well, it does mean that the person claimed to be liable, the producer or the distributor of the product, cannot suffer the application of a law different of the law of the principal place of business of that person when that person couldn't foresee that the product will be introduced in the market of the country whose law is demanded to be applied by Article 4, 5, or 7. That means, imagine that we have Article 4 and there is a coincidence between the habitual residence of the person suffering damage and the place where the product was acquired. Well, that's great. We can apply Article 5, and we are going to apply the law of the habitual residence of the person suffering damage. And we are going to try to apply this law in relation with the liability of the producer of the product. Imagine the computer. Well, this is not possible when the producer of the computer, the company making the computer, proves that the computer was, in that case, acquiring a country where the producer of the country couldn't foresee that the computer is going to be introduced in the market. Is going to be sold. This is important. Sorry, the telephone is ringing, but as I have explained to you in the first video, I'm at home with all my family, and it's impossible to avoid this kind of things. I hope that it's already ended the phone. So, if we are talking about this example, habitual residence of the person suffering the damage and the place of where the product was acquired, and there is this coincidence, in principle, following Article 5, we can apply this law to the liability of, for example, the person producing the computer. But when this person proves that he couldn't foresee the marketing of that product in that country, he said, well, I never sold my computers in that country, but I sell my computers in, for example, France, and some persons took these computers, and at the end, without my permission, they sold these computers in this other country, but I had no idea that my computer will be introduced in that country. In that case, it's not possible to apply that law to the producer of the computer. In the example we are using now, it's not possible to apply that law because the person claimed to be liable couldn't foresee that the product will be made available in that country. I hope that this idea is also clear. So we have the three articles, 5, 4, and 6, but any law applicable according with these articles could only be applied when the person claimed to be liable could foresee that the product would be made available in that country in a legal way. In another case, we are going to apply the law of the principal place of business of the person claimed to be liable. So at the end, when this provision, when it's not possible to prove, not because the charge of the proof is on the person claimed to be liable. When this person proves that he couldn't foresee this introduction in the market, then we are going to apply the law of the principal place of business of the person claimed to be liable. I hope that this is also clear. And you have here also the articles of the convention. It's easy to see that. If you have any doubt, of course, you can contact me. So this is the High Convention of 1963, but we have also the Rome Convention. And going back to the Rome Convention, I have to explain to you something I have forgotten to explain in the last video. I'm going to see that is Article 4. Well, in Article 4, I explain to you the general rule. The first, the habitual residence of the person claimed to be liable and the person sustaining damage, and when there is no common residence between the person claimed to be liable and the person sustaining damage, the law of the place of the damage. And I ended there, but there is another connection, Article 4.3, exception clause. That means that when the law, when there is a law of other country manifestly more closely connected with the damage, with the tort liability, than the law designated by paragraphs 1 and 2 of Article 4, then the court should apply this more closely connected law. This is the idea of Article 4.3. It's an exception clause that is very typical in private international law in the field of conflicts of law. The idea is that we have some fixed connections, in this case, habitual residence of the person sustaining damage and the person claimed to be liable, first connection. Second connection, the place of the damage. And in principle, this is the connections we are going to use, but when in a specific case, in a certain case, it's clear, manifestly, that there is another law more closely connected with the case than these laws, then we are going to apply this law. And there is an indication that is very significant here, is that a manifestly closer connection with another country might be based in particular or on a pre-existing relationship contract, such as a contract. So, as I have explained at the beginning when I was talking about the case I have proposed to you in the last video, the case about unfair competition mixed with contractual liability, I have said that there is a contractual liability and a tort liability. The liability based on unfair competition is a liability based on torts, not contractual liability. So we are applying Article 4. But in that case, imagine in the case we were dealing with Thunder, the relationship between Ton-Laherm and I have explained to you that the Tom Laer can introduce a claim based on contractual liability against Thunder, and also a claim based on torts based on unfair competition provisions. Well, the second claim, the claim based on unfair competition, is a claim based on tort, and we are going to apply to this claim Article 4 of the Rome 2 regulation. But in that case, maybe, for example, it could be applied Article 4.3 and said, well, as this unfair competition claim is connected with a contractual relationship, maybe we can apply to the tort claim also the law applicable to the contractual obligation. The idea is we have two different claims based on the contractual aspects and non-contractual aspects, but these are connecting the same parties. And as we have between the parties a contractual obligation, we can consider that in torts, the most closely connected law with the tort is the law designated for the contractual obligation. The law applicable to the contractual obligation could be considered through Article 4.3 of the Rome 2 regulation the most closely connected law, also to the tort case. This is what I haven't explained to you last day. Well, really only because I have forgotten to that. I was thinking about that, but the video continues, and I didn't realize that I have forgotten to explain that. So I'm explaining to you today. I hope that this is also clear. Well, so we have seen in product liability, we are in products liability. We have seen the Hague Convention of 1973, and as I have explained to you, in some cases we are going to apply the Rome 2 regulation, and as we are going to apply the Rome 2 regulation, I have explained that point that we haven't seen in the last video. And now we are moving to Article 5, that is the article devoted to product liability in the Rome 2 regulation. And this article establishes different possibilities. And there are differences, of course, many differences with the Rome 2, the Hague Convention of 1973. First of all, here we cannot say the same we have explained on the Hague Convention of 1973, in the sense that the Hague Convention of 1973 covers both contractual and non-contractual liability linked to a product. Here we cannot say that, because we, in the European Union, we have a regulation on contractual obligations, applicable law to contractual obligations, Rome 1 regulation, and we have another regulation applying to non-contractual obligations, Rome 2 regulation, and we are in Rome 2 regulation, and Rome 2 regulation is not going to apply to contractual obligations. So here it's important to distinguish between contractual and non-contractual obligations, contractual and non-contractual liability. The problem that the Convention of 1973 resolved through that mean that saying we are not going to distinguish between contractual and non-contractual is not possible here, because for contractual liability we must apply the Rome 1 regulation. And the second point is that here is not exclude the liability of the person selling the product to the person suffering damage. Well, we are going in the future how these circumstances are going to put in problems the courts and the persons applying the regulation. The regulation, the first connection is the law of the country in which the person sustaining the damage had his or her habitual residence, but this habitual resident must be in the the damage occur. So when the habitual residence of the person suffering damage and the place of the damage where the damage occur are in the same country, then we are going to apply the law of that country when the product was marketed in that country. This is very similar to what we have seen in Article 7 of Hague Convention of 1973. When the product was not legally marketed in the country, we are not going to apply the law of that country. We are only apply the law of that country when the product was legally marketed in that country. When there is no coincidence between the law between the residence of the person sustaining damage and the place of the damage, or the product was not legally marketed in that country, then we are moving to point B of Article 5.1. The law of the country in which the product was acquired if the product was marketed in that country. So the law of the country of acquisition of the product with the same condition: the product was marketed in that country. Or the law of the country in which the damage occurred if the product was marketed in that country. Well, the same idea. The product should be marketed in that country, and the third connection is the place where the damage occurred. So, resident of the person sustaining damage, when is the place of the damage, the law of the place of the country where the product was acquired, and the law of the country in which the damage occurred, even in all these cases when the product was marketed in that country. And I have said that this provision of that the country was marketed in that country is similar to the provision of Article 7 in the Hague Convention of 1973, and we are going to see here that this is exactly the same idea. However, the law applicable shall be the law of the country in which the person claimed to be liable is habitually resident if he or she could not reasonably foresee the marketing of the product or a product of the same type in the country, the law of which is applicable under A, B, or C. So, when the product was marketed, even legally marketed in that country, and the product claimed to be liable could not reasonably foresee the marketing of the product, then the only law we can apply is the law of the country in which the person claimed to be liable is habitually resident. In the Hague Convention of 1973 is the principal place of business of the person claimed to be liable, and here is the residence, the habitual residence of that person, that in most of the cases will be the same. And here we have in 5.2 the same exception clause that in 4.3 in the general rule, where it's clear from all the circumstances of the case that the tort delict is manifestly more closely connected with a country other than that indicated in paragraph 1, the law of that other country shall apply. A manifestly closer connection with another country might be based in particular on a pre-existing relationship between the parties, such as a contract that is closely connected with the tort delict in question. So, as you can see, the same idea that in Article 4.3. So, we have Article 5 of the Rome Convention. We find here three connections: the residence of the person sustaining the damage, the law of the country in which the product was acquired, and the law of the damage. In all these laws could be applied only when the product was marketed in that country, and these laws cannot be applied when the person claimed to be liable proves that she or he could not reasonably foresee the marketing of the product. And as we have seen, we have here also the exception clause of Article 5.2 that is the same that the exception clause in Article 4.3 of the Rome II regulation. Is that clear? I hope so. So I'm going to end now in a minute. I'm going to explain at the end. I'm going to give you the case you have to resolve, and the case you have to resolve is linked to a real case. The Baskirian collision of two jets. The Baskirian case is the collision of two jets in 2002 over Germany, a passenger's jet and a cargo jet, a passenger's jet flying from Moscow to Barcelona and a cargo jet flying from Bahrain to Brussels, crashed in the mid-air over Germany in 2002, 71 casualties, no one survived the accident, and it was a very complex case. You can find in the internet many information about that case, and one of the actions that were introduced in that case was an action on product liability against Honeywell, that is an American company producing the TICAS. The TICAS is a tool in the planes that is designed to avoid collisions. When two planes are very close, all the planes have a TICAS inside working, and when two planes are very close, then the TICAS in one of the planes sends an order to the pilots saying, for example, climb, climb, climb. And the TICAS in the other plane issues an order saying descend, descend, descend. So the orders are, of course, contrary. When the TICAS in one plane orders to climb, the TICAS in the other plane orders to descend in order to avoid the collision. What happened in 2002? The TICAS in the both planes ordered correctly. The TICAS in the imagine the plane coming from Moscow to Barcelona, the TICAS ordered to climb, and the TICAS in the plane coming from Bahrain to Brussels ordered to descend. But what happens? Happens that the pilots in the plane coming from Moscow didn't follow the orders of the TICAS. They followed the orders of the air controller. The air controller ordered the plane to descend. So the TICAS said, climb, descend. This plane, the plane coming from Bahrain, descend, but the pilots in the plane coming from Moscow descends also because they follow the orders of the air controller. And there was, as I have explained, a demand, a claim against the producer of the TICAS, and you can ask why. Well, should have a system of reversal order. The system of reversal order implies that when, in this case, the order is, it's difficult, the order is climb, the order is descend. When this plane descends and the other descends also, the TICAS should issue a reversal order to the first plane saying climb. This is the idea. And this apparently didn't work in a correct way because at the end the planes crash. And this is, as you have seen, a case of product liability. As I have said, you have a lot of information about this accident in internet. There was the claim was introduced before the Spanish court, so there are a decision of a court in Barcelona, a first instance court in Barcelona and Court of Appeal in Barcelona also, and the Supreme Court of Spain has also decided about that. And it's a case related with the case I'm proposing to you now, and you can see the case now in the video, and I'm going to share you the case also through the Moodle. And that's all. You have all the next week to answer the case I'm proposing to you. And next week I will give you another video. And the next video, and it's not going to be longer than one hour. I think that it's enough 1 hour, and I'm going to give you 2 videos, no longer than 1 hour each of them, next week about company law. And as you know, you have the possibility to contact me through email, and if you need that, we can even have a conversation through Skype. I hope that all of you are very well and safe, and I hope the moment we can meet